All right. We'll call the meeting to order at 5:31. First item on the agenda is roll call.
Kristen Runge,
Here.
Joe Zetzelsberger. Here. Tricia Brown,
Here.
Brian Wallace. Here. Chris Thomas. Kevin Phelps. Here. Chris Elner. Here.
All right, next item on the list is approval of the minutes. Did anyone have any corrections or clarifications for the minutes? All right, seeing none, does anyone have a motion?
Motion to approve minutes?
I'll second that.
All right, all in favor?
Aye.
Aye. Opposed? Okay, next up is public comment, and I would like to, could I make a public comment? All right, today's Indigenous Peoples' Day, and I'd like to start out today's meeting by reading our land acknowledgement. The village of Waunakee acknowledges that the land we occupy is Tejo, ancestral territory of the Ho-Chunk Nation, people of the sacred voice. The Ho-Chunk are stewards of these lands and waters since time immemorial. Settlers attempted to forcibly remove them from their homelands by exploiting a series of land secessions and treaties, including the Treaty of 1832. However, the Ho-Chunk resisted these conquests and asserted their sovereignty as a nation. We address this trend of dispossession by upholding the Ho-Chunk way of life, sovereignty, culture, language, and environmental practices. Acknowledging these atrocities is only the first step towards reconciliation. Through relationship building, education, and action, the village will advocate for a shared future with the Ho-Chunk Nation. So in observance of Indigenous People Day, and also like to remember that we are home to, or we're home to, a number of Native American boarding schools, and I've recently become aware of the impact that that has had on a lot of nations. So we'll remember that today as well. All right, any other public comment? Would anyone like to make a public comment? Go ahead.
Tim, did you push the button on there to make sure the lights?
The button.
There we go.
Okay. Thank you for having me in. Tim Schell, Director of Secondary Curriculum and Instruction for the school district. I'm here to speak with respect to your consideration of an ordinance on keeping chickens in the village. Obviously, there are many dimensions to this issue. I just want to speak to two aspects that have an educational relationship. The first, of course, as you know, we have our school buildings within the village. Currently, we do not do any significant work with livestock in the buildings, partly due to ordinance, partly due to our program design. But if we were to do something more with livestock, chickens are something that schools in many districts do approach, because it's certainly one of the more manageable and feasible aspects. It's also something that you don't even have to be in large scale production agriculture to potentially have relevance, for students. So one thing we would ask you to consider as you approach this matter is creating at least an institutional provision for our agricultural program to potentially include raising chickens in the future if our ag educators felt that would be useful programmatically. The other thing our ag educators wanted me to speak to tonight is to make you aware that within agricultural education, there is a type of student project called a supervised agricultural experience, or SAE. And that's really more of a student-driven project that's overseen by the ag teacher. But that can take many different forms. And obviously, if you're a student who wants to do an animal-related SAE and you live on a farm, it's fairly straightforward to engage in that. But for students who don't have access to a production farm, and we have many students in our ag program who do not, the ability to do something with chickens, if they want to do a livestock-affiliated SAE, is really attractive. And many of the municipalities that are within the district do allow chickens at residences. However, village is the heart of the school district. Most of our students live in the village. And, right now, if a student wanted to do an SAE as a village resident that involved chickens, they couldn't. Now, obviously, there's a lot of things that go into raising chickens, as with any other animal. If you were to go in this direction with the ordinance, you'd have to kind of navigate those, and any student who is raising chickens would have to comply with that. But I guess I just want to close by saying programmatically, would really like the flexibility, and at the same time wanted to make you aware there's a potential benefit to individual kids at home if you went in this direction. Thank you.
Thank you very much. Yeah. Other comments today? All right, none? All right. Next item on the agenda, business item number 1, discussion regarding an amendment to the village ordinance on the keeping of chickens. And it's an item for discussion only. So to you, Tim.
Thanks, Kristen. This item was referred to the Plan Commission from the village board at their meeting last week. And included in the packet are several items, and some of the commissioners this may look familiar. There's an example of a draft ordinance and a sample permit that the village discussed back in 2015. In addition, there's a list of surrounding communities in Dane counties that regulate and allow keeping of chickens. In addition, there's a draft of an ordinance prepared by one of the village board members that could be inserted into Chapter 14, which is the licensure section of the municipal code related to the keeping of chickens. So really, the referral was made here. I guess I didn't prepare any documents other than to share these with you, but to see what your pleasure is moving forward in this light. So right now, as Tim mentioned, there are certain areas of the village where chickens are and aren't allowed by ordinance and or by licensure. And I think one of the things that would be a desirable goal, if it be that of this body, is to have those two sections, Section 14 licensure, as well as land use and zoning, Chapter 133, be consistent, so that there's no debate of, oh, this allows this one doesn't, etc. So if we move forward in that direction, I think that an amendment will be needed to Chapter 14 regarding licensure, as well as Chapter 133 regarding the zoning. And then of course, the discussion would be what would be the appropriate zoning districts in which chickens would be allowed, if that's the pleasure of the body. So that's all as by way of preparation. I guess I didn't anticipate a lot of discussion this evening, but I'm certainly open to comment. Our village attorney is here and available to answer questions. Let's see where you'd like to go with this. If it is come back next month with a draft ordinance, or what, if you wanted to start going down the path of starting to give semblance to some meat on the bones, I'll say, no pun intended, with numbers allowed. If you wanted to start talking about that as a frame for staff to start building around, keeping of X number of chickens in X number of residents, if it be the pleasure of the body to allow those in institutional zones, maybe include a draft that would speak to that as well.
All right. Plan commissioners, what questions or comments do you have? All right, go ahead, Joe.
I just want, one of the things that's listed in here is the different neighborhoods and the restrictive covenants. And there's a number of them that say that they are silent. I happen to live in Meadowbrook. I'm very familiar with our covenants, and they are indeed silent when you specifically look for chickens. But there are a number of things in there that would not necessarily prohibit, but make it extremely difficult for somebody in that neighborhood to have chickens. I would suspect that some of these others are very similar. Most of the covenants are, very similar across all the different neighborhoods. So just wanted to make sure that the commission's aware that that is also out there, and that silent, is kind of a broad.
But one thing, and jump in here, please, Brian. So generally, covenants, private covenants are private, enforced by a private body, not enforced by the village. So even if the village moves forward with an ordinance that would allow that, if private covenants for a certain neighborhood or neighborhoods would prohibit that, or if there's some means by that HOA to review and say no, that would supersede, enforceable by that HOA.
That is correct.
We didn't rehearse that.
Other chicken questions? Yes.
Just a question over the pros and cons or benefits of having it be a licensure program if chickens were to be allowed versus just allowed and then governed with the rules like any other zoning requirements would be. It seems like on an annual basis, that could be a lot of logistics or headaches
Yeah.
for staff.
So I think that's a judgment call in terms of the degree of regulation, if you will. I think one of the benefits of licensure is that provides another a stopgap of review and point of you can rescind a license, for example, depending upon how the regulations would be written, versus if it weren't and it were just allowed, for example, by right in certain zones, then it would become simply a zoning enforcement and only a zoning enforcement issue versus, again, if it was done by zoning and licensure, that's another means by which that could be regulated. Does that answer your question in terms of?
Yep. And maybe it's just, if that's the case, I understand the point of that, thinking about a longer term renewal or something, I'm just thinking if you're going to invest and have the cages and all of that, you want to have it for more than a year. So just thinking through that.
Other questions? Comments? Go ahead.
So I'm assuming we could carve out the schools specifically if we wanted to. Because I would tell you that I would support that 100%, that the schools get it, the community doesn't get it. So just throwing that out there to the committee members, that's something I'd support 100%. I think there's a educational value to it. I think it's separated enough from other neighbors. It makes it a lot easier to enforce for the staff and the police and everything else. But that's sort of where it ends for me.
Other comments? Go ahead, Chris.
So I'm fairly familiar with this. We've been talking about it for quite some time. I would echo Kevin's comments. One of the enforcement things, and as I went through all the different things in here, there's really not teeth in this as far as I'm concerned. Sure, we could say you can't have them anymore if they don't abide. But what if they do and get chickens again? What happens? Is there fines? Is there what type of penalty? Is there a ban that they can't have chickens from moving forward? This just seems like it's not. There's not enough penalty, I don't think. Same thing with that they get a late fee of $5. I don't think anybody's going to get too bent out of shape about the $5 in this situation. Unless they're selling the eggs for profit, then that's hitting into their profits, I guess. But that was one thing. But I'm not opposed to this idea for residents having it completely. But I can already support the schools wanting to have it for institutional.
Brian and Chris, do you have any questions?
I can try to address one of those.
Oh, sure,
So
yeah.
we have a number of ordinances that I will call like property maintenance ordinances. The easy one is sidewalks. And typically what municipalities do, if you have someone who's in violation of the ordinance, but they're not reacting to what staff is telling them, is, you initially have a conversation with them, basically say, you gotta shovel your sidewalk. If they don't do it, then you send a letter. If they don't do it after that, then you typically send a letter that basically says, look, if you don't start doing this, then by an X date, we are going to start fining you for every day that you don't do it. And whether it's snow and ice, or you just don't keep your property in good condition. That's really the enforcement mechanism that you have on things that relate to property. The initial fine is not that much, but every municipal ordinance says that each day that you have a violation is a separate violation. After 30 days, now you start to get into thousands of dollars worth of fines. That's how it's enforced. It's a slow process, but it ultimately does work. So if you have somebody who has chickens and, they violated the ordinance and they don't get rid of them, that is probably the most standard process. You would theoretically have the right at some point in time, if you wanted to go to court and get an injunction and then have them removed. But while slow, the process of fining on a daily basis does ultimately work, because at some point in time that those fines get to a point where now the property owner is like, holy cow, I actually need to do something about this. So just while the initial fines may not be that high, there is a mechanism that ultimately usually results in enforcement.
So just out of curiosity with that, how much are our attorney fees as we go through that process to try to get that done? Is it
Well,
gonna outweigh the
typically the
fees that we're
attorney
gonna
is not.
charge or?
The attorney may assist with drafting the letter, but usually everything's handled at the staff level, so there aren't significant attorney's fees.
So again, that's a staff level thing that they have to take their time to take care of.
That is true.
All right, Brian, I think you had a comment. Am I putting you on the, Chris? No? No, so neither? No, okay. It's all right.
I didn't see anything in here. Is there a disposal of said chickens when the interest and the novelty wears off? Who's responsible for that?
Well, since the regulations aren't written yet, I think we want to write them such that the property owner would be.
Okay, because I would have some concerns on that. In addition to some of the concerns I voiced in the past, is that it's cute at the beginning and then the novelty wears off and now we have a chicken coop and 5 chickens. And I know what the easy solution would be for a property owner. But we need to have some mechanism in place probably for that as
I
well.
believe there was a discussion at the village board level where we would have language in there that would not allow that to occur on the property.
Or within the village limits or the prop.
Yeah, sorry,
Yeah.
on the property or within the village
Go
limits.
to your
Yeah, but that
neighbor's
was
house.
actually something that was brought up when this was initially discussed at the
Yeah.
board. And I think there was an acknowledgement that there would need to be language added to that effect.
It's not, there's something in here, but you can't slaughter the chickens.
Oh,
Yeah.
okay, well then maybe, sorry.
That you can't slaughter the chickens, but I would assume, I don't know this, but it would have to be written in that they would have to be taken to
Appropriate.
an appropriate processor of chickens or however, I don't know what the term is, but
If that's what the plan commission and the board, I mean, that seems reasonable, and I think that that's what the board was getting at. I don't want to speak for the board members, but I know that this was, at least we touched on this topic.
Chris, did you have any comments? No. I had a couple of questions. We, in both the draft and one of the ordinances that was referred to us, chickens could be acquired before the licensing. And if we were to do this, I'd like to see the license acquired first and then the chickens. Can we do that? Like, you have to have a license before you can go out and buy your chickens.
Yeah, I mean, the only community that I'm aware of, I mean, Verona allows this now. I'm actually a little surprised in looking at the page because I thought they got rid of their licensure, or maybe they just expanded the time period, because I know that they were having staff issues with an annual license. But yeah, that's my understanding, is the way they handle is you don't get the chickens. And I mean, because the other way to look at it is they are illegal. As far as I'm aware, they're illegal right now. And so essentially you'd have to change the code, both the zoning code to make it clear where they would be allowed. If you're going to have a licensing or permitting process, you would modify that. And then typically, anytime that you have a license or a permit, you do need to acquire the license or a permit before you can engage in the activity.
Okay. All right. And then our ordinance would not, I think it probably needs to be clear in whatever ordinance we write that we don't supersede the homeowner association rules, because I wouldn't want to be in conflict because we don't supersede. Am I correct in that?
We don't supersede. I would be careful with that though, because there's a lot of ordinance provisions that we have right now where we don't supersede. And I think it would be difficult for staff to essentially review the code and add that. I mean,
Yeah.
I think it's just legally, that's the way it is. In other words, if the village were to approve the allowance of chickens, changing the zoning code and then adding the licensing provision. And now I'm just looking at, looks like our Arboretum Village says no fowl, including chickens. If you lived in Arboretum Village, you still would not be able to have chickens. And that's just the way it is.
Would we issue a license in that?
We
That-
should, one of the things that I think we would need to have as part of the application process is we would need the applicant to swear and affirm that there is nothing associated with their property that prohibits the keeping of chickens.
Okay.
And so I would hate to have a situation where the village has to go through and look at the homeowners association documents, because to me, that seems, at least my opinion is that seems too much on staff. But I think that you need to have something in the application where they swear and affirm, so that if they've lied, that in and of itself would then be, not only would they be in violation of their homeowners covenants, but the fact that they've lied on the application would be a reason why you would pull the permit.
Yeah, I don't want to be in a situation where staff says, here's the license, and the homeowner association says no, and then the excuse becomes, well, the village okayed it. Why are you, my neighbors, objecting to this? Because that would just be a headache for staff, I would think. Yeah.
Yeah, I would recommend writing the licensure portion such that it would be that, as Brian said, that would be either part of the submittal, whether, acknowledgement of, I've read and understand the covenants for my neighborhood and understand that they are allowed or are not, whatever the case may be, so that there's a clear statement of attestation to that fact. Whether it's submittal of the if there's something from the covenants, but if it's obviously if they're not allowed, they're not allowed.
All right.
Would it be, sorry, go ahead. Would it be reasonable to have something that would allow it at the institutional level for the schools and not the residents?
If
By whether it's by ordinance or however,
Short answer, yes. It depends on how the regulations are written.
okay,
So if it's confined that narrowly, you can write regulations that way.
all right, and then I see just notice date of passing inspection, so I'm assuming that however this might proceed and somebody is applying for a license, that somebody's going to go out and actually physically do an inspection.
I think that's really going to be up to the process is going to be, the plan commission is going to make a recommendation and the board is the ultimate authority on this. I guess you certainly can have inspections if you want, whether that's in there or not. I think that we have the authority to do it. It may be, now it may be that you don't necessarily want to do the inspection initially, but you, as part of the application process and as part of the permit, the property owner is agreeing that we have the ability to come onto the property if there is complaints by neighbors that basically say, yeah, I understand that they're keeping chickens, but they're not following the rules. One of the things that municipalities, I'm not focused on Waunakee, but one of the things that we wrestle with is when we do have complaints by neighbors or things of that nature, we don't always have the authority to go onto the property. And, I'll give the example of the Kisting property where the house ultimately came down. We had to go through the process of getting a special inspection warrant through the courts because we were not allowed to go into the house. And so one way to deal with that and to avoid a scenario where we have questions by neighbors, but is to get the approval on the front end from the property owner to come and do the inspection.
Right. Other question I had, because this is how it would go. I think I like chickens. We don't keep chickens for a lot of reasons, including our HOA. My husband would build a chicken coop, keep a chicken for a year, and then he would turn it into a accessory dwelling for a lawnmower. When the chicken coop, this is how it would go at my house. So the man wants a shed, in the worst way. And I hope he's not watching this. But when the chicken coop is no longer used for chickens, do we have the ability to regulate it as an accessory dwelling? Do we have a responsibility for asking them to maintain an unused chicken coop? They can become real nuisances sometimes because they're difficult to maintain.
Yeah, so that may be in part what Brian was alluding to, in part, and there's the slaughtering aspect, but just in terms of so you don't have these structures and pens and chicken wire or whatever. If there's a provision written that, within X number of days, the coop and the associated equipment, structures, et cetera, has to be removed. Now, you could write that. That's an enforcement issue, but you could write your regulation that way.
Okay. All right.
One more
One more question, one more comment.
So I'm trying to find a reason to say yes. Where I'm struggling is all of our, call it restrictive covenants. I don't see anybody screaming saying we need to change this covenant to get chickens. And we have quite a few of them on here listed. And where I see this is the only areas that really don't have this. And silent, I'm kind of taking Joe's lead on that. That's probably, if they wanted it, they'd probably put it in there. It's silent though. The ones that we have around the community as our older sections of town are really the only ones that aren't listed in here that I can take or taking from this. So I'm trying to have a reason because there's a reason that they wrote it in not to have them in their covenants. So what is that reason?
Good question.
Obviously they have those covenants in there they want to be able to sell their lots and have the residents happy and all those things. But I'm not seeing anybody stepping forward from any of these because they usually have a board that oversees these HOAs. And I'm not hearing from those HOAs. I haven't been hearing from those, even though this topic has come up several times. So I'm looking and saying, yes, we have had residents ask us to have chickens. However, the majority of it is no. So Brian, you brought up Fitchburg, and this is where my
No,
question
I
is.
brought up.
Or I'm sorry, Verona, which says, where it says allowed with license. When they switched, because they used to not be, is that right?
Yeah, they were in the same position as Waunakee, as chickens were not allowed, and then they modified their ordinance to allow them.
And what was the basis, or what caused them to want to?
I think just they heard from another number of residents who said we'd like to have chickens. And I'm sure that they have a similar situation as Waunakee, where there are some homeowners associations that have covenants that don't allow them. But from the residents that they heard from who were not subject to those, they said that's sufficient for us. We want to allow chickens.
Do you know, Brian, if any of the homeowners associations have since altered their restrictions after Verona approved it at the municipal level?
I'm not aware, but it would be odd that I would be made aware of that.
Makes sense.
But it can be done. If a subdivision says, boy, they just passed this ordinance in Waunakee, but we don't want it, we can change our covenants at that point.
I would say it can be done both ways. In other words, you could have someone who is silent that then modifies their covenants to prohibit it. You theoretically could have a homeowners association that says, hey, wait a second, they just made this legal in the village. We in fact want to have chickens in our homeowners association. So you could have their covenants modified to allow it to. So it could work both ways.
All right, so we have go ahead, Chris. Yes.
I'm sorry, I got a question. So we talked about licensing and potentially having the license before they got the chickens. I would assume they'd have to be in compliance with everything that's in here. So like the size of the hen house, all of that stuff that's in here would have to be, they'd have to be in compliance with it before they got the license. So essentially they have to have the chicken coop and everything already built and in their property before they can even get the license. And who's checking?
I think the way that it normally happens is they come and get the license, they get approval of the license, and then they build everything consistent with what's in the code.
So we talked before about potentially attesting to something, it's not, this would be allowed in my neighborhood. And they attest to that, would they have to attest anything like that they're going to build in compliance with the license?
Well, yeah, but I would say whether they attest to it or not, they're subject to doing it. The village could build that into the application process and signing it, whether you do or not. If you issue a permit to somebody and you have standards in your code, they're going to be required to abide by those. And whether or not we have it attested to, we're going to be able to enforce that.
Okay.
So a possible way of addressing that would be, as part of your license application, you would have to submit your site plan showing where the coop is on a site, what it looks like, all the things to ensure that, okay, here's your license and here's your site plan. Now, essentially, you are entitled to build what you said you were going to build. And so now we have something on record of where it's going to be, that it meets all the requirements. And just, so I'm not, because I wasn't around in 2015, I'm not necessarily advocating for or against this. It's merely a starting point in terms of language. So I can't really say why, when you ask why is this or why is that, I don't know. But we can use this language certainly as a starting point to bring back to you to start evaluating and saying, yes, this makes sense, or no, this doesn't, or, oh, it should be modified this way or that way.
Any other comments? Chris?
I'm trying.
Try it.
To come
I want
to
my
this.
neighbor kids to have chickens so I get the eggs.
Brian, maybe this isn't just for this, but in general with our ordinance, do we have something written in that when somebody's getting a permit or anything like that, that they can't be in arrears on taxes or something like that?
I do believe that we have something in the ordinance. And the reason I say that is because that is standard for alcohol licenses. And at one point in time, within the last 20 or 30 years, there was a lawsuit because municipalities had that in for alcohol licenses, but did not have it in for other licenses and permits that were issued. And the court said that was illegal. In other words, if as part of the issuance of an alcohol license, somebody cannot be in arrears on their taxes, that means that all of your ordinance provisions related to licenses and permits have to require the same.
Okay, good. Thanks.
One of the things I it kind of brings me back to on this is of all of the different things besides the pool that I heard from residents when was running for the office was and from all ages, right? So I think we almost owe it to them to have the conversation. I've only heard from them the positive side. I haven't heard kind of the counterpoints to it. So I think that's part of the discussion that needs to take place if we decide to move forward with something like this. But I think I agree with you guys as far as the schools, that seems like a no-brainer. But I do think there's enough interest out there that we should continue this.
I'd agree too. I think we've got some concerns that hopefully we can work out. Or maybe we won't work out, but either way, I'd like to see us look at it more.
I guess I have one more question. Is the board in support of this and they threw it back to us to come up with the ordinance? Or are we supposed to decide if we're supporting this to come back to the board to tell them that? Because I'm confused on it.
So the board wants to take this up, is my understanding. It doesn't mean that it's going to be adopted, but they definitely want to have the conversation. I think because this does implicate zoning in light of the fact of our existing zoning code, the statutes require the plan commission to take it up within a certain period of time. Now, I haven't looked at, because we've never had this issue before, and I hope we don't have the issue now. At some point in time, if a plan commission doesn't act, the board can act. But I think what the board is hoping is that there's a good discussion that you've already started about an ordinance. And at some point in time, even if this is what I would say, is even if you're opposed to the chickens, I would still be involved in the process, because ultimately it's going to be a village board decision. And so sometimes it's like, I don't want to see this happen, but if it's going to happen, boy, I really want to make sure that this is part of the process. That's why I think you want to have a good discussion on this, because it is ultimately going to go back to the board. I don't know what they're going to vote on, and we don't know, because there was a preliminary discussion, and the board understands that because our zoning ordinances are implicated, it has to come to the plan commission. But I think the goal for the plan commission is do as good of a job as possible in putting together something that makes sense, that it'll go to the board. It may get tweaked a little bit and it may be approved, it may not. But I think more along the lines of Tricia's comment of the board wants there to be a significant discussion and analysis of this issue.
So with that being said, do you think the board wants to know from us 7 members how many people support it? Because if it's only 1, or it's only 2, or it's only 3, do they care? Or is that not something we want to pass along to the board?
Well, I guess what I would say is, I think even if it's not supported by a majority of the board members, I think that it makes sense to participate, because it is a zoning. Ultimately, there are going to be things related to setbacks, for example. So, okay, well, even if I'm opposed to this ordinance, boy, I want to make sure that coop is at least 5 feet off the line as opposed to 2 or something like that. To me, that's why there's value for the plan commission under all circumstances to have the discussion.
I do think, at least from my perspective, I want to hear as many other perspectives as possible. Yeah. All right.
So I do have a question to help in writing this, and that is, so there is a sample of an ordinance from several years ago. There is a sample of licensure requirements for purpose of discussion. So far, I've heard, I don't know if there's consensus, but generally no one's objected. It's appropriate associated, keeping of chickens is appropriate associated with educational institutions. Now, we have a institutional zoning designation. However, schools aren't the only use that's allowed there. What about like churches? The reason I'm asking you this is is in trying to discern the way to craft it. If it's narrowly tailored to just educational institutions or allowed in the institutional zone. Any thoughts on that?
So outside of schools, churches, I mean, I could see nursing homes perhaps wanting to keep chickens for the benefit of their residents and the contact with it. What other institutions would fall under institutions? Businesses?
Generally,
fall under-
no.
no?
Bear with me a second while I pull open our code. So I wasn't planning to get this far, but nonetheless, that's okay.
It's like a pop quiz.
Okay, permitted uses in institutional zones, cemeteries, churches, hospitals, nursing homes, clinics, libraries, museums, aquariums, municipal parking lots, public utility offices, utilities, water storage tanks, public auditoriums, exhibition halls, fairgrounds, libraries, parks, playgrounds, other public outdoor recreation, and public recreation and or community centers.
Okay.
So for this first draft, would it be fair to say you'd like this at least initially narrowly tailored toward schools and educational uses that are in those districts?
I think
I'm
that sounds
hedging
fair.
it.
What do you guys think? Yeah.
Agreed.
Mhm.
Okay,
All right.
One additional question here.
Mhm.
As I'm reading through this, there's a section right at the very end that says this ordinance shall be effective upon publication. Do we have the ability to delay that implementation for some period of time? What I'm thinking is, since the HOAs would have the ability to make changes one way or the other, give them an opportunity to do that.
Yes, you always have the ability to set a different date in the future if you'd like.
Excellent, thank you.
All right. Any other questions?
What's interesting about the HOAs though, and I can only speak to a few of the subdivision or developments, but a lot of them are gonna be prohibited just based on setbacks. There will not be room for one.
Oh,
Yeah.
yeah, setbacks, fence rules.
Yeah, and
fence
that right
structure,
there
yeah.
by itself will kill any
Yeah.
ability to have a coop.
Yeah.
so I'd like to ask one more question then in terms of starting point. So commonly, I would say number of chickens allowed in other communities are 5, no roosters. For purpose of text, should I start there? And discussion,
Definitely no
Or-
roosters.
or do you have a number different than that? And frequently, educational facilities are on grounds large enough that may allow for larger facilities. So would that same standard be applicable, or do you think it would be reasonable to allow more in situations where there's educational uses? And if you want to think about it, that's okay.
I would, for the educational purposes, I would defer to the ag teachers at the high
Yeah.
school. How many chickens would they think are reasonable? How many chickens would they need for educational purposes?
Can I ask you a quick question, Tim? Does the school want roosters or just hens? Or,
I actually don't know. Let me circle back to our ag team and I can either come back to a meeting or let Jim know if they have a strong preference. I think the main intent of the ag team is they want their options open, but I'll get that question answered.
All right.
Tim, I would note from my perspective at least, and this is something that was brought up at the board as well. If we have a limit of 3 dogs, cats, whatever, something along that line, I feel we really need to take that into consideration. I don't know what that looks like yet, but to say somebody can have 3 dogs, but they can have 5 chickens or whatever, that rubs me the wrong way.
All right.
I would just say that I think we probably want to get chief involved in that because usually the number of dogs sometimes involves police enforcement issues. And so just to let you know.
All right. All right. Other questions or comments? All right. Thank you very much. On to the next business item then. Discussion of amendments to the village zoning ordinance related to signs, Article 8, also an item for discussion only, action on a later date.
All right, bear with me while I get my pages caught up here. So this particular ordinance, the Plan Commission looked at, I believe, last year. Yeah, last year we started discussing it, I think in July, and then at their December meeting, we started actually reviewing the draft that's included in the packet. So the purpose for tonight isn't really to start diving back into that tonight, but it's really to reintroduce, because some of the members here were not part of that discussion last year, is to reintroduce that draft to this body and say, let's pick it up next time. However, let's try and focus it. So the area that I think is most in need of scrutiny is the area related to temporary signs. That's the area where, for those of you who participate in that discussion, where we have, I'd say, the most enforcement issues. So with that being said, I'd say be prepared to discuss this. However, focusing on temporary signs, and that begins on page 25 of the packet. I'm not sure what the page number exactly is of the ordinance, but it's page number 25. And what we can start there. By means of jogging some memories, we had a brief discussion about yard signs, for example, and the Plan Commission started talking about how many yard signs are appropriate in a yard. And as you can imagine, there are a lot of opinions about that. So I don't anticipate this is going to be a brief process. However, it is something like every regulation, a line's got to be drawn somewhere. And that was really the intent of that with this. The other area that I think, and we'll get there, but is at least the issues that we see is placement of signs on public property. Now, we know our code already says no placement of signs in the public right of way. That's almost a daily enforcement issue, because even if people know that, they seem to disregard that. But nonetheless, that is a portion. But the other piece tends to come with the promotion of festivals, and where can banners and things like that be placed within the village to promote those events. So part of the discussion. But anyway, to focus, I would say let's begin our discussion next time focusing on temporary signs, and that's beginning on page 25 of the packet. Obviously, we're here to take any questions, just general questions right now, but I wasn't really prepared to start talking about the specifics. I may point out too, though, that this draft that's in here comes from Verona, which a couple years overhauled their zoning code and rewrote it, that in theory, and according to my sources over there, are compliant with the 2015 Reed Supreme Court case regarding sign content. So hopefully, not on the degree to which this has been tested, I don't know, and meaning challenged by anyone in
It is
Verona.
not.
Okay. So, but nonetheless, this was created after that court case and is intended to be content neutral. So any questions at this point?
Just clarification, Tim, the notes that are in here in blue, are those your recommendations or your notes?
There are yes to some, and others are questions, but yes, some of those are recommendations. So you'll see in the draft, there are several highlighted sections. Some of those are for discussion, but again, Brian and I have started this over the last several months, and for example, there is a provision in there in our current code that gives the Plan Commission a lot of latitude to issue variances or special exceptions. And I think that is something that we're going to want to look at, and probably, and maybe you can weigh in on this right now, but probably strike, because what would that be based on? Because now we're into regulating First Amendment rights. And I think that's a bridge too far, in my opinion, but I don't know.
I would agree with that, because at the end of the day, there's variances under the statutes. Parties can seek area variances and they can seek use variances. And really that's the standard where an exception to a zoning code should be judged, as opposed to giving too much leeway, let's say, to a governmental body that invites a claim on the specific situation if something occurs. And keep in mind, every time that we act, we usually have people that are going to be upset no matter what we do. And this concept not only creates the possibility of a lawsuit related to that specific decision, it also allows for criticism of our rules in general. In other words, we should have rules and we should follow them. And then there are variances that are allowed under the statutes, and there are standards for those variances. And that's effectively what we should follow, as opposed to, oh, in this circumstance, somebody doesn't want to do something, doesn't rise to the level of satisfying the standards of an area variance or a use variance under our zoning code, but we're going to allow it anyway. That's where municipalities get into trouble.
All right, comments or questions? We will discuss this in November, right? Okay. Any preliminary to November comments? or questions?
I just had one question. So the only place in here that differentiates between a business and a residence is where it says yard, or does yard apply to everything? I'm just,
Good question. So the way codes are frequently written is based on zoning district. Ours is currently is a mix of that. So we call out like commercial and industrial zones or PUD zones or residential zones. So you may, I'll see if I can refer to, give you an example. Okay, so on, this is on page 22 of the packet. Near the top of the page, B, it says residential conservancy and ag districts. So the call out is R1, R2, R3, PUD, A1, et cetera. So in those zoning districts, those standards apply. So that's a way we can do it here to differentiate between residential and commercial. That would be a common way to do it. And I think that would be a way that would provide clarity in X zoning district. These type of, for example, temporary signs would be allowed. So in the draft, I think right now there's a placeholder. It says zones XYZ or something like that. That's meant to fill in the blank of in the R1, R2, et cetera.
and the only fear that I have is if somebody has 4 kids that are all in fall sports, they'd be breaking the law to put 4 signs in their yard.
At least favorite child doesn't get.
So that you're.
Pick your favorite kid, I guess.
So maybe you were part of, Kevin, you were part of that discussion last time, where we just started getting into that. Like, where do you draw the line and with regulations, somewhere is the answer. We'll need to draw that line somewhere. Or we haven't discussed this, but a way is do nothing, become Las Vegas, allow any sign anywhere, anytime, any size. I don't know if you'd want to do that. That may be construed as a safety hazard for people driving, but that's way one end of the spectrum. And so there's a lot of, I don't know if that's gray is the right word, but just a lot of choice in here, I'll say.
I think
But-
Vegas is more excitement than we're used to. Yes.
Is a third option to do what we're doing right now? Right, that's not do nothing.
No,
Because we
right,
have-
this is
right?
what I would construe as targeting the areas where we have the most issues. So predominantly, we haven't had a lot of complaints or concerns about the vast majority of our code from commercial users or industrial users. It's really the temporary signs. That's where we get enforcement issues. And then the other one, like I mentioned before, of where to place temporary banners for festivals and things like that. What's appropriate. Because right now there's by our code, we have a process that people are supposed to come before the plan commission. But again, like we were talking about in the exceptions, now we're getting into First Amendment rights. On what basis would you say yes to one and no to another?
So
But for the reading of the content.
the questions I had around temporary signs in the commercial end of code, there's this mention of a time limitation on banner signs. So, this building for sale banner on the side of a building. And realty signs are also not called out as being allowed past the 60-day limit for the sample ordinance. And, remembering back to 2009, people had signs in their lawns for 120 days or more because their homes were for sale for that long. Could we look at making exceptions for that? Or would we require people to come in front of the plan commission if they had a commercial building for sale for a year or more to get a renewal of the sign?
Well, I think one of the things that we want to do is we don't want people coming before you.
Yeah.
Um,
That's a lot of
and
work.
second of all, one of the things that we have to do at a staff level is we have to come up with rational ways to distinguish that is not based on content.
Okay.
Because as soon as we start getting in content, and that's why we can't keep our existing code is, we have enforcement issues right now because because we have content-based sign rules and we need to make modifications. And in, I guess at the end of the day, in all likelihood, staff is going to be recommending changes to the plan commission of the village board that is going to change what is existing right now. And it may make some people mad. And the justification is we need to change our sign code to bring it into compliance with the Supreme Court decision, or we risk multiple lawsuits.
So just to call out something else. So what we've tried to do, like I think a number of other communities are doing when they undertake this exercise, is use of graphics or images. So Kristen, you mentioned a realty sign. Well, we can't call them that because how would you know that but for the content? So as an example of that, on page 30, we call them post signs. So that's the manner, right? Time, place, and manner. That's the manner at which the message is being conveyed. It's a post sign and it's defined by the image. And then there's area, height, number, location, etc. So that's an example of what we're trying to do here to clarify what those types are. So we don't get in the mix of calling it a multifamily subdivision sign or whatever the case may be, where the only way you would know that is by reading the content. So
in November, when we go into this, will we have time to ask questions in detail?
I think this is going to be, honestly, several months. Yeah. So, but to focus things, I think that temporary sign, as I mentioned, page 25 would be a good place to start.
And just to clarify, I know we've talked about this before, but this only affects from whatever point in time it would be in place going forward. So past signs would all be grandfathered in.
To a point. So for example, like signs in the right of way, those aren't allowed currently. So there is really no such thing as a grandfathered sign in the right of way. But in answer short, I mean, yes.
Build the signs that are on the facade of a
We-
building or something already right now. We're not.
To the extent that signs are legal right now, they're grandfathered. If it's an illegal sign, it doesn't receive grandfathering protection. And the other thing I would say is just to kind of set expectations, whatever ordinance comes out of this from the plan commission of the village board, I don't think that you're going to love it. I think you're going to say, I like 80% of it and I'm willing to live with it. I do not ever like to blame courts ever. They get to make the rules. We got to follow them. I think this is the only court decision that I've ever in an open meeting been critical of. It's not practical, but we got to abide by it.
We just want an equal level of unhappiness across everybody. Is that the goal?
Or equal level of happiness.
All right. Any more? Do you need any more from us right now?
Right now, no.
No. All right. And then last business item is discussion on an amendment to section 133-995 of the zoning code regarding parking requirements for certain residents and non-residential uses. Item for recommendation to the village board.
Okay, we again, the plan commission, last time we talked about this was at our July 10th meeting. I would refer you to page 33 of the packet. So you may recall last time we had a bit of discussion about industrial manufacturing, warehouse type of uses and how that could be regulated. So what you're seeing on the top of that page 33, in the lower red box is suggested language that hopefully addresses or meets your expectations or desires of the nugget of that discussion, which is, so for one parking stall, we talked about a workforce, excuse me, a workforce size, number of employees, one parking stall for each full-time equivalent employee on largest work shift, plus one stall for each vehicle owned by the business. And stored at the site shall be so here it is, shall be constructed. However, the land area needed to accommodate one stall per 1,000 square feet is required. So if hopefully I captured that correctly in that if they have say a large building with a lot of automation and not many employees are needed, reserving the space to meet that area standard would be required. However, the number of stalls built would only be required as part of that. So I would say first use or the use with it had that number of employees. So first question would be, is that language in the bottom box consistent with what your intent was, or were you thinking another direction?
Because I think we were thinking that it's one person in there now, it's all automated. They go to sell it. 50 employees come in,
Yeah.
you need to have the ability to have 50 parking spots. That's what we're getting at here?
Yep.
Okay.
But it could be grass.
But
If you don't need it, it could be grass and trees.
Right, it doesn't, right, that whole area doesn't need to be paved. It just, that larger building would need to demonstrate there is capacity, should the use change.
Here's a trivia question. Do we know what our largest building is? Or would it be the high school?
I should know that, but I don't offhand. I don't know, maybe, do we have an administrator in the,
Could be Northview. Yeah,
probably could be the high school.
okay. Tim's gone. How many, you might know off the top of his, how many square feet the high school has.
I still
Okay.
have a little bit of a concern with this language. We're in the ballpark. But saying that the land area needed to accommodate that is required doesn't necessarily say that it has to be buildable space. So my concern is, maybe initially it's being used for drainage or, whatever. It's still space that, it meets the rule, but it's not actually implementable necessarily,
So it needs to be on a site plan, sort of designated,
but not necessarily built. Yeah,
Almost like in an easement.
yeah.
So Octopi's building, according to On Milwaukee, 165,000 square feet and a 200,000 square foot building will go up on the land across the road. So theoretically, they're 545,000. Does that mean we would say they need 545?
By this,
It's a lot of parking. Yeah, that's a lot more space than they've got.
That's a
A
ramp.
ramp,
Yeah.
that is a ramp, but yeah, yeah. Okay, this is more difficult than.
Joe, to your point too,
Mhm.
sorry. Joe, to your point too, are you talking about if the land is like this? But it's still part of
Perhaps.
it, there's no way you can put a parking ramp there, so
Yeah.
you couldn't use that space, is
Yeah.
that?
Yeah.
Yep.
I just want
that's-
to clarify,
That's what I'm
okay,
getting at.
yeah, that makes
Or if
sense.
it's wetland, you can't fill a
Yeah,
wetland.
and there's a ton of reasons behind why you wouldn't be able to actually use it for parking, but it should be theoretically available to actually be used that way if need be.
Tim, any considerations of like on-street parking in the area? Though that would all be done as part of like a conditional use permit or something with the site plan when they're applying for an application, correct? So that's,
generally, we don't count on-street parking to count towards someone's parking requirements. Someone could say, for example, I'm gonna build my whatever building business, and there's plenty of on-street parking, so now I get to use the public right of way to accommodate my parking. Well, what about the next person? So I think the use of, in my opinion, on-street parking is not a good idea in terms of a calculus. It's certainly acknowledged for overflow, but not as these stalls shall be dedicated to X business. So maybe Joe, a modifier, to accommodate one stall per 1,000 square feet. A floor area is required to be shown on a site plan, something like that. Because, for example, if there's a wetland or a drainage basin, well, obviously that's reserved for those uses and would not be considered applicable
Yeah.
or appropriate.
Maybe you could use like building envelope.
I'm sorry.
What the building envelope could be for parking. They have to demonstrate the building envelope.
Yeah, I think that's a good call.
I'm not sure for our very large buildings, if 1,000, one stall per 1,000, yeah, that seems, lot 60 down in Madison, I don't think has 554 parking spaces, just for comparison.
Yeah, with the octopi example, I'm really wrestling with that one.
Yep. So, yeah. Is there guidance? I mean, I would think, is there guidance out there somewhere? I don't know that I. know any
actually, the person I should
standards.
ask is my husband. I actually think I could look and get some, like what the what the commercial real estate industry says for industrial uses
Yeah.
as a common practice, or what the demand is from the tenants, because
Yeah.
that does just seem like a lot of parking.
Yeah. I mean, it's different if it's a 2,000 square foot hair salon, right? But
Or if it's 100,000 square foot Target store,
yeah,
right?
yeah. yeah.
Something like that.
Yeah. So. That's big.
A lot of land.
It is. It is.
We're just discussing. Did you want to share?
Okay, so if I understand, so I'm on page 33, right?
Mhm. Yeah.
And so we have the existing language and then that has one stall per 1,000 square feet of floor area. That's what's in black. And then the red language. And so I see suggested change. So if the suggested change is it's one parking stall for each full-time equivalent employee on the large work shift, plus one stall for each vehicle owned by the business and stored at the site shall be constructed, period. If and then it sounds like we have after the semicolon, we have some language that's intended to be there in case the use changes, like the facility grows. But, and if I understood the discussion that the Plan Commission was having, there's a little bit of a concern about one stall per 1,000 square feet because that may require too much. But I think another way to approach it is just, okay, we have the rule. You come to us, you have a facility, you're subject to the language the new language in red that Tim has drafted that's before the semicolon. If you change your facility, you're going to have to come back to us to get additional approval, because now you've enlarged your facility. You're going to be subject to that same standard, though. You're going to have to come back to us and say, okay, now you've enlarged your facility. You have to show that you are providing parking that satisfies one parking stall for each full-time equivalent employee on the largest work shift, plus one stall for each as it goes on. I guess is that.
I think the issue is really the other way,
Oh.
which is if you're not going to increase your building footprint, but you are going to increase your number of employees.
Oh, okay.
And so you have, let's say an example, like in an automated facility where you have several, whatever, CNC workers and you don't need that huge staff compared to some other more manual labor of assembly or something like that. Well, in scenario one, you'd have, let's throw out a number 10 employees in a fairly large building due to automation. For whatever reason, the use changes, the building stays the same, but now that building could accommodate a different use that now requires 5 times more employees or more.
Okay, so why don't we just change that to say, I mean, you could essentially build in language that gets at that issue, but keeps the same standard. So notice if the concern is the standard on one stall per 1,000 square feet, we can modify this to say, it's not the change in the facility, it's the change in operations. If you change your operations from what you proposed to us when the parking was approved as the site plan, you need to come back to us to get a subsequent approval. And the standard that you're going to be subject to is the same standard that you were subject to on the front end.
Right, but how do we ensure that that land remains available for 5 years from now? You know what I mean? That says, okay, the use changed, you have to add 50 parking spots, and they're going to say,
You're
well, I
not
don't have
going
a
to be
spot
allowed
for
to
it.
change your operations under our code because you wouldn't satisfy the parking. In other words, it's going to be incumbent upon the operator to make sure that happens, or else they're not going to be able to operate.
So I guess the question is there a way to sort of secure that ahead of time? That says on a site map, this is what we're designating as the
We
additional.
should build that language into the code, and then when the parking is approved on the front end, you build that language into the approval that puts them on notice that this exists. And so for, let's say, for that initial operator, you can't, don't split your lot and all of a sudden sell it to somebody else, because that maybe is going to limit your ability to resell your existing property and facility, because whoever comes in is going to be subject to those same, you've taken away the flexibility that you otherwise would have had.
It's difficult to predict what changes in use are going to occur over time to capture, every situation to ensure that. I mean, I think that there are going to be times where someone's going to come in and go, oh, there's not enough parking left, or I'm sorry, there's not enough land area left on parcel X to accommodate a larger workforce. And so someone's, they'll have to look elsewhere. But I think the intent of this, correct me if I'm wrong, is to try and limit those situations as much as possible. And that, I guess, is what the attempt is for this, that there's sort of two standards, but you don't have to build to the one. You don't have to construct the parking field, the parking stalls at present. And it's still, that situation would still, or could still arise, that not every site is going to be able to accommodate every use. I mean, it's there's nothing I can think of off the top of my head, and even in doing some research that you're going to be able to anticipate that to that degree, reserve X amount of land, because it's just, in some instances, it's not gonna be possible. So I don't know.
You also, I mean, to essentially protect the future purchaser of the property, you can also, I mean, we don't normally do this, but if it is a large enough concern, the parking approval can get recorded on the property. And so essentially the concern that the Plan Commission is worried about, you build that into the code, you build that into the approval to give the future purchaser notice that if they change the operations, that the parking may be impacted. And then because you've recorded it on the land and you get approval from the property owner when they seek approval of the parking plan to get it recorded on the land, that gives the subsequent purchaser notice of, hey, if you're planning to buy this land, modify the operations of the facility such that there's going to be a lot more employees, we're letting you know that this is going to be an issue. So that way you don't have an inappropriate seller sticking it to the next buyer because they're not aware of it.
I feel like that, even going back, and I remember this a little bit from July, that having it tied to employees, it may be a challenge for monitoring it and making sure that, oh, you only said you're gonna have 35 employees. Well, you have 50 now. Like where does that, who keeps track of that? And then so the square footage seems to still make the most sense, but I feel like there's got to be some sort of happy medium, because if you're going to invest so much in building, I'm going to go back to Octopi's beautiful new warehouse, that as an owner, you're going to make sure that there's parking for your trucks and your vehicles. And I think the market somewhat dictates whether or not another business would go in there if they had or didn't have ample parking.
What was the standard when, for example, because Octopi seems to be on the forefront, what was the standard?
Yeah, our current standard is the one in black at the top, 1 stall per 1,000 square feet, again, for that.
So did they get a
use.
variance? Although I'm not saying there's 500 stalls, but they do have.
Yeah, no, so that those lands are zoned planned unit development, so there's an opportunity there for some negotiation because of that zoning.
Okay, so because based on that, then, and again, I will defer to those that write with this kind of language all the time, but it goes to the up to 1,000 square feet, or up to 1 stall per 1,000 square feet. So that you have some sort of leeway there in the case that the owner can come and show that, hey, look, I don't need 1 per 1,000, I need 3/4 or half, right?
Well, but there's also language at the bottom. I mean, one of the things that we need to do, no disrespect, is to take away the discretion from the Plan Commission, because right now we don't have standards. I mean, I don't want to be too direct and blunt, but we've created so many exceptions for different businesses that if we were to get sued right now, a court would look at us and say, well, what are your standards? And then we would say, these are the standards. And then the plaintiff would walk in all of the approvals that we have that don't apply those standards. And the judge would say, well, in fact, I don't think that you have standards. So how can you hold this new business to that? And so I think part of reading the change at the top is also to read the change in the bottom, which still allows for some exceptions, but there's guardrails on what's being granted. And so I just raised the comment that you made, Brian, because it's definitely a valid one with the way that I think we have operated, but it may not apply as much when we start having the newer guardrails.
Yeah, so what I would say to that, and I think this actually came up last time, I thought 10% was pretty small on a percentage. So if we are going to have the so-called guardrails, we need to expand it a little bit. ultimately staff is gonna filter through that. But if someone like Octopi comes and says, I only need 75%, if we're restricting them 10, that's only 50 stalls in this scenario, which is insignificant in the realm of the building.
Yeah, and my flip side to that would be, let's put together the standards that we buy into so that we don't have exceptions, because what we really need is just everybody's subject to the same rules. I mean, that's what we need.
I think the delta might be different. Like if you've got a 1,000 square foot building, one parking stall, 2,000, two parking stalls, like that's reasonable. But when you get to 545,000, like, yeah, I mean, it's a curve, not a straight line, maybe. So maybe there's some sort of, is there I feel like there should be a commercial guideline, and I feel silly for not knowing what it is. When we get up to industrial uses, how many would be advisable and how many would protect us for a reasonable degree of change when buildings change hands? This is not what I thought my questions would be about today. It's not what I have in my notes necessarily, so.
Well, I do feel disrespected, Brian, but beyond that, I'll say that, could we put in there something along the lines for your Octopi for some reason has been this? Could we say that 1,000 up to a certain size building, and then beyond that would be a different category?
I mean, my suggestion would be to put in more I would put in more objective standards. In other words, and now I'm getting too out over my skis because I haven't talked about this stuff with Tim, but it's like, you can always have a sliding scale of, this is, up to this, this is essentially a one size fits all standard. If you're looking for different standards based on the size of the buildings, obviously staff can look into what are the more commercially, what are the commercial standards that you had identified, Kristen, and come up with if it's this number of square feet, then it's one stall. If it's this number of square feet or over, it's a half a stall or something like that. But I mean, I think it's just, we've had standards that we haven't been applying, and we need to update this code with something that you're comfortable with, that quite frankly does not provide as much flexibility, because we want to be able to say to people, we applied this standard to the first company in the door, and then when the next company in the door says, what's the standard? Here it is, and we applied it to them, and so on and so forth. And to the extent that you have discretion, then you're going to run into a company that's going to say, I disagree with you. I think I should be able to do this. And we're going to be in a real bad spot from an enforcement standpoint.
I agree with that. I think if you look at the standards outlined for a high school where you're talking about one stall for every 3 students over 16 plus one for every staff member, like I can see somebody wanting to put another warehouse in and coming and saying, well, there's certainly less people in my very large warehouse than there are in the high school. And yet my parking requirements are higher. So I feel like we might be, that's what I'm fixated on that. We'll tweak it for next time, maybe. And Brian, what did you have? You had a question?
Well, I think what Brian just talked about is kind of echoes what you just talked about as far as size, like, hey, it's up to 100,000 is X, up to 250 is Y or Z, right? And create those incremental changes per stall, stall per whatever.
Parking ramps are also a possibility for everybody if we have that. I mean, I look at Fiskars in Middleton, they have a parking ramp for their people. They didn't have enough space on the ground, so they built up on a parking ramp. And I know that's expensive, but that's what where they wanted to be.
It's also better for a car and easier to plow. Joe and Kevin? You guys have any?
The only comment I would have is and I don't want to open a can of worms, but I'd love to know these exceptions that we've made over the years. We obviously made them for a really good reason, right? We didn't want more blacktop. I don't know if we went bigger or smaller in most cases. I'm guessing we went smaller, but it's almost take a hard look at why we made these exceptions in the first place, because that might sort of give us an answer to what we want to do here. If we made a consistent, exception across the board, maybe that's something we should look at.
I'd say the main area, and correct me if I'm wrong, because I've only been here a relatively short time, is in multifamily housing. So we've looked at over the years, or over the last 5-ish developments for multifamily housing, relaxing those standards based on strict adherence to our current standards. And we, I think, have used, and I want to say like the Middleton standard, which is kind of what ours is proposed at right now for multifamily. But that particular use was the catalyst really to look at everything. So I don't know the other uses, commercial, industrial, et cetera, but I do know that there have been a lot of variation from strict adherence to the multifamily residential standards. So maybe, I guess what I'm hearing, because I don't know if we're going to resolve this tonight in hopes of at least checking a few check marks off. Maybe we'll come back, or not maybe, we will come back. We'll look at what that sliding scale looks like on a threshold on X building square feet and bring that back before you and let you know what we find.
Tim, I think that's kind of where we hung up on, right? Is the rest of this we were pretty good on?
Well, there's one area we're going to talk about next. It's on the same page, but I think so. I think so.
Yeah, because to the school, that's a separate.
Yeah,
That's a
separate one. Mhm. Hey, Chris Thomas, did you have any thing about? Okay, cool. Want to make sure I didn't overlook you.
So we'll bring this one with for industrial warehouse manufacturing, et cetera. We'll bring that back next time and we'll put our heads together and look at that sliding scale or whatever other standards. I can't tell you, I looked elsewhere, not completely exhaustively, but the area standard for industrial is a common one based on building square footage. The employee size is another common one, but then you can't please all the people all the time. And you can't contemplate every use change to accommodate every site. So it's a challenge, I'll say. But all right. So next, let's scroll down same page. So one of the other items we discussed last time, excuse me, was that exception, the notion of exception. So what I've done to address that piece, below the table on near the top of page 33, is what was currently or is currently proposed under 9, and then the current language under 16. So the language under 9 was an attempt to address that some flexibility. However, rather than create that, my suggestion, which is stated at the bottom, and then I think Brian started talking about this, was essentially wrap those numbers 9 and 16 into a new 16 we talked about the concept of a floor and a ceiling. And that floor and ceiling as currently written here is 10% above, 10% below. At some point, as Brian noted, if we're 50% above and 50% below, now that seems like that doesn't really pass the test of rational. Now we're just like, potentially going into like variance land. But anyway, for discussion, so the proposal here is eliminating that new number 9 and then modifying section 16 or subsection 16 into A and B, which is as stated in the text with a 10%. So I don't know, Brian, if you want to say anything about that number, if there's some to Brian's comment about being more flexible, if that's where you're going, Brian, than 10%, would 15%, or is there somewhere in there that would pass the test of, well, now we're being, we're giving too much discretion to pass the reasonableness?
Well, I mean, I would start with the standpoint of fundamentally, we don't want to be granting exceptions. In other words, we want to have standards that apply evenly to everyone, and those are the standards that we apply. Honestly, I wouldn't go above 10%, because I think when you start getting above 10%, now we're going to be starting having different rules for different entities. To me, it's a compromise of providing some flexibility under certain circumstances for certain businesses when they can actually, because then and I think the language that Tim has put together is probably as good as you can put it. But, you look at section A, when the applicant can demonstrate demand through supporting evidence that includes analysis of similar or comparable uses. So I mean, the onus is going to be on the applicant to be able to demonstrate that the rules that we have in place should even be modified. But at the end of the day, you know, if we've done a good enough job in drafting and approving standards, there really shouldn't be even any exceptions. And then that puts us in the strongest position of, you know, being able to tell everybody when they walk in the door, well, these are our standards. We just did a reanalysis of them. We believe that these are appropriate and we're going to apply them to you, and everybody gets treated the same. And that's the ultimate goal, is to treat everybody the same. Or else you start running into different zoning and other constitutional changes or constitutional challenges regarding equal protection, and you're treating one person better than you're treating us. So, I mean, I would keep it at 10% and focus more on getting the standards exactly where you want them, as opposed to coming up with greater flexibility for different entities, because we haven't had a problem yet, but at some point in time, we probably will.
So the suggested change, 16 exceptions, does that replace 9 and 16 above here, or?
Short answer, yes.
So when I look at this 9 and 16 goes out, 16 becomes the standard, whether it's or part of the standard.
Correct. So the verbiage in red on the bottom of page 33 would be the new
And there's
verbiage that
no,
would.
well, it does say if they can demonstrate the change. So I could get behind the 10% to Brian's comments if we had some sort of graduated scale.
Yeah.
Because again, if I look at the rest of these, you know, the way we've gone through and broke out the different applications, and we have pretty detailed analysis here, pretty detailed requirements. The 10% still applies to every one of these applicably. And so the biggest one is the 1 per 1,000. And just trying to make sure that any, you know, I guess I think where this conversation started was that any building that is in use now or in use in the future, that we don't restrict other uses if something changes, right? 20 years from now or whatever. That was where this started. So I could get behind this 10% language as written here, if on number 8, if we could come to some sort of graduated scale. That's where I would be at.
Another question I just had when you were saying that, Brian, is if there's a building over X, speaking of graduated scales, like let's say 250,000 square feet, would we require a parking study as part of the development approval process for that we could use as a way to make an educated decision?
I would think the answer is yes. Or for example, if you get, and I'll throw out, no, not disparagingly, it's just an example that popped in my head, which is like an Amazon facility like is being proposed down in Cottage Grove. I would think we'd want some kind of traffic analysis of what kind of traffic that's going to generate both on and off site. For a building that's, you know, 1 million whatever square feet. So yeah, I think that would be appropriate. At some point we would do that.
I just feel like in some of these, it might be better to just be specific instead of us trying to guess what the best case scenario is going to be when that comes forward.
Yeah, I think like I said, it's over time, it's really difficult to guess whatever possible iterations of change in use that's going to accommodate everything. It's at some point in time, there's going to be a decision made of, oh, this site will work or this site won't work. We can accommodate expansion here. We can't accommodate expansion over here. Not necessarily of a building footprint, but of where people are going to park.
Go ahead.
I'd just say I agree with Brian and what he was stating, and I can support what you're supporting. I do want to go back just for a second though, Brian. You talked about maybe encumbering the property at one point when we were talking about things. I was going to say something and I didn't at that moment. I just didn't get it out fast enough. We have to remember that business needs to get financing, and when a bank sees encumbrances on it, they may end up owning that building and they don't want that. So it's going to be difficult on their financing. So just remember that.
Yeah. And I guess what I was trying to say is, I mean, trying to balance the notification issues. I mean, at the end of the day, the property's already encumbered. In other words, if somebody else comes in and changes the operations of the facility, they need to come in and get a new parking study or they need to evaluate the parking based on our standards. What I'm trying to, when you record it on the property, what you're trying to avoid is a scenario where, and for a commercial business, you really shouldn't have to provide this protection. But, oh, I'm going to buy that building and I think that parking, I'm going to be able to utilize the parking approval that applied to the predecessor. Well, if they had 15 people working and you're going to have 75, you're not. And now all of a sudden you've purchased that property and now you need additional parking. And so providing that notice to the purchaser of effectively a zoning encumbrance that already exists. I do definitely understand though, from the banking perspective, they want to see as little recorded on that land as possible.
Other comments?
Can I ask a clarifying question about the maximum number of spaces? So this document, we're talking about minimum number the whole time. Then we're saying you can go 10% above the minimum. And that it looks like they don't need approval from us, from the plan commission. But then if they want to go another 10% above that, that's where we would have that.
No, you would still need to authorize 10% above. So we're saying there's a standard, right? And someone would come in and go, well, I need to go above that. You would still need to sign off on that. Again, with that evidence.
With the guardrail
with
being
that-
10%.
The way I read number 9 now, it says that it shall not exceed the minimum by more than 10%.
9 would go away.
Yeah,
9
Yeah,
would
so-
be replaced by the 16.
yeah. So the number 9 was a new attempt at, again, I think that was setting a floor, perhaps the minimum number. Yeah. So this 16 is addressing that as well as a ceiling. That's the intent. anyway.
So when we tell them they have to have a minimum number, that's the minimum and the maximum, unless they come to us and ask for an additional 10% either way.
I think my understanding is the way that we're going to set this up is you're going to have a standard that this is the number that you have to have.
Yeah.
And then if you want an exception from that, you can come to the village with a potential exception, but that exception has guardrails of 10% either lower than what's the standard says or 10% higher.
Okay.
Is that accurate? Okay.
All right. Other questions or comments?
I'm trying to think of a scenario where that 10% above is not sufficient. I don't know if anybody's got anything. I'm a little concerned that range is, a little
So I
tight.
can offer where it used to be, and I think that applied mostly to retail, and we may have talked about this a little bit last time, but retailers oftentimes would park a store for Black Friday, and then 360 or whatever days of the year, most of that parking area isn't being used. And so I think we want to say, well, gee, is that a really good use of land for a host of reasons? So we don't need, company X, we don't need that other than one day a year. Like, okay, is that really appropriate then?
And I think the other way to look at it is, I think when the village and other municipalities do their parking studies, they do not anticipate on-street parking. But there are going to be times when that happens. I mean, there's just, and you don't want to plan for that. It's just you adapt for those particular days. It happens with churches, I think, at least Blessed Sacrament School. I can tell you, usually that church is, the parking lot's just fine. There are certain days, Christmas, other days, you're parking 3 blocks away.
I think one of the things I'm wrestling with here is, we've got that range, but if somebody goes out and has a parking study that says, hey, I need 40% above, we don't have that flexibility that I'm.
Well, I mean, theoretically, you could build in another exception that is narrow as possible to deal with the parking study issue. I think the goal, though, is to try to hit our standards so that when they do a parking study, our standards would actually meet that parking.
That would
study.
be ideal.
Theoretically, you could build in some, I mean, you have to be real careful though, because that parking study can't all of a sudden eat up the rule.
Yeah.
But you could add another subparagraph, or you could add language, a parking study, an independent parking study approved by the village or something like that. I mean, how do I say this?
I understand your
Okay.
caution.
Yeah, okay.
Yeah, yeah.
Yeah.
I get that.
And alternatively, you're hopefully citing places where there are side streets and people can,
Yeah.
if we need to temporarily increase parking.
Well, and the other
Park
thing
on
I
the
would say
street.
is all of a sudden, if you have a couple parking studies that show that our standards aren't sufficient, that's when all of a sudden you need to look back at your code and say, oh, maybe we need to update the code because we had good information that we relied upon at the time and now circumstances have changed and
When you come back with a sliding scale, over 100,000 or whatever it's going to be square foot, is that going to differentiate between commercial and retail?
Short answer is right now, no, because the way the use that we targeted for this discussion was really more industrial, manufacturing, warehouse, et cetera. If you want that, if that's the way you'd like us to look at it, we can. Again, I think that that runs, in my opinion, the danger then of those sort of, Black Friday type of scenarios happening. And is that what you'd want to see?
I'm just worried that we think that a big warehouse needs fewer spots. And if we, God forbid, ever got a new grocery store, they would want more spots, right? So it seems like those are two different discussions that shouldn't fall under the same parking limitations.
the flip side to that though is we don't always have to do what they say. I mean, we have legitimate public welfare reasons as to why we want to limit the number of parking because of the surface area. And yeah, I mean, I'll just leave it at
So-
that.
Generally, the commercial uses are based on two things, either occupancy or size. So for example, like retail, I think the proposal is to change it to 1 stall per 300 square feet of floor area. For restaurants and bars, it's based on number of patrons. You don't really have patrons in industrial use or warehouse use. We're talking about an area standard for industrial. It's different than 1 per 300. It's 1 per 1,000. So I don't know if that would necessarily be applicable because you have these different uses enumerated already.
Do we have any other additional questions or points that we should talk about this? Or
I just really have more of a
information?
general
Okay.
question of have you all had a chance to look at the rest of this? I think we've looked through these a number of different times, but for this sliding scale on the industrial uses, are we close? Is there anything that jumped out at people saying we got to change that, whatever?
My only other question was regarding nursing homes, 1 stall per employee on the largest shift plus 1 stall for every 6 patients. And I was just sheerly curious, how many patients do we know we have at our current nursing home? And what would parking look like if they were held? Not that we would require them to build a parking lot now to that standard. But I can also pick up a phone and call about that.
So you're talking page 35, right?
Yeah, page 35, yeah.
1 stall per 6 patient beds plus 1 stall per employee on largest shift.
Yeah, I'm wondering. I was trying to figure out how many employees they have per shift. I can make a call for that and find out.
Yeah, okay.
Yeah, I'm
Because I
just-
think obviously that depends on the size of the facility.
Yeah,
I don't know if there is a standard ratio of caregivers per bed. There may be.
yeah.
The only other one I had a question on that same page, the hotels, motels,
Mm.
if they have a big restaurant inside, are they still just considered a hotel motel?
So we talked about this a little bit, I think, if you recall, when Cobblestone was in here, and no, we'd add those 2 uses. However, on page something to consider, I think there was an 80% standard for combination. Page 37, thank you. So number 11, there could be some allowance for not a strict adherence to the aggregate of both, but there could be 80% depending upon the uses. 80% of the sum required individually. So generally we would look at both uses, but it may not require the total in aggregate, if you follow. This would allow to go down to 80% of that total.
Tim, just general question, has that been pretty close to the parking areas dedicated in some of our newer mixed use developments?
I'm sorry, say again?
Is that 80% combination, is that pretty close to what we've been approving or including in the more recently approved?
Good question.
retail
I'm
mixed use?
not sure. I think in the past, we've looked at uses individually and said, you know, for this use, you need this, for this use, you need this. And if there's a third use, you need all of this. This would allow for some flexibility to account for some, whether it's overlapping hours or just people, you know, people being there for both uses, if you will, in the case of a hotel and a restaurant.
All right, any other comments? Good work.
Are
This
we,
is a
are we,
lot.
so do you think we're close? The reason I say that, because if we can bring this, the issue, the sliding scale for industrial, if we come to resolution, my suggestion would then be, if you're okay with this, then we can bring this back for at a future meeting, not necessarily next week, but to the public for a public hearing and say, hey, we're ready to recommend this. Or are there things that jumped out at you in this version?
I'm good.
Okay,
I'm good.
okay.
Overall, I feel pretty good. What I'm wondering, would it be prohibitive from a level of effort to sort of compare? These are some examples of certain, you know, businesses or whatever in here, what they currently have, and if that were to come before us today, what that would look like. Is that something that would provide any value? I don't know either.
I guess I need a little bit more direction, because that right now the way I'm interpreting that is really
Yeah,
broad.
so I'm gonna base what Trish said as well, in addition, is as an example. So Kramer's buildings out there, right?
Mhm.
When they come in front of us, I would assume that they are falling under retail, business, and commercial services, because we don't know what the specific use is of each one. We talked about a coffee shop.
Oh, the multi-tenant building down.
Correct, but
Yeah.
we don't know what the specific uses are gonna be, so doing it combined is difficult at that point, right? So I would suspect that it fell under retail, business, commercial services. So to the point is, okay, how do we, or can we take and look at that, right? And say, hey, where did that fall? Did that meet that requirement or not, right?
Is it,
So I think
okay,
that's what Joe's
no,
getting at.
that helps. So yeah, we can do that.
That's just one example, but hey, when we approve that with the parking, if this was the standard, did it meet at that point in time?
Yeah, I'm sort of looking at the, you know, based on what we did and what we would do, are there any that are so terribly different that maybe we need to take another look at those?
Yeah, and those all, to Joe's point, and then you got the apartment complex there, right? There's
Sure.
several recent ones that you could just, you know, compare and contrast, just loosely compare and contrast, see where it falls compared to the spec or what the standard might be.
I never want to use a real example, but maybe I can use a real example. So I know that one of the topics in the community for, I don't know, 10 years, is the Main Street Diner, which they want to sell only to a restaurant owner. There's no parking at all there. Are we going to be able to accommodate that for them, or is it no way? Because the only way they're going to sell is if it's a restaurateur that's coming in, I'm just basing on the sign they have up on the building. And then there's, I think, some apartments up above it,
Mhm.
yet there's no parking there other than street parking. So how would this apply?
Yeah. Or grandfathered in because it's in a historic district. That's something we have to think about. Oh,
I think we need to talk about that further. I mean, I don't know if it's built into here. I know most communities, I guess I'll use Mount Horeb as an example. I mean, they have a lot of downtown businesses. There's no way
mhm.
that usually there's a different rule for downtown is what I would say. That's my experience. And then basically you have to, because clearly everything downtown for the most part is off street.
Mhm.
Or I'm sorry, on street parking,
Yeah.
apologize. And I know, well, I guess that the example I would give there is they bought land and put a parking lot in. Of course, they just sold that land to Steve Brown Apartments. They're putting up an apartment complex, so now they're looking at buying other land for a parking lot. But that's a valid point of how do you deal with places where there legitimately cannot be any parking except for on street.
And not that it's gonna happen tomorrow, but eventually they're gonna wanna, DOT is gonna wanna take up that entire main street for cars and not parking too, so 20 years down the road, this could be really restrictive. All right. I just borrowed trouble. 10 years down the road? Like in the DOT a little less today. All right. That's saying a lot. So I got that on recording, didn't we? Dang. All right, anything else? Nothing? Oh, do we? No.
We'll bring back again what we've talked about, the sliding scale, a standard based on a sliding scale for your consideration. I'll bring back some examples for Joe. And we'll go from there.
All right. Is that our end of our business today?
There is another, the next agenda item is an update on joint plan
right.
commission, which is, there isn't one tomorrow.
Yay, we are 3 minutes until. Is there another?
Move to adjourn.
Thank you.
Second.
All in favor?
Aye.
Aye. Opposed? All right, Jared, can we put it up on the board?